Both sides ready to proceed?
Yes.
You each will have 15 minutes to present your arguments to the court, and the appellant may reserve up to 5 minutes. Just let me know, please.
Good morning, Your Honors. My name is Thomas Skidmore. I represent the appellants in this case. If it may please the court, Mr. Lenigan's here on behalf of Mr. Filip, and I do have some representatives here from the Wakefield Run Master Homeowners Association. If it please the court, I would like to reserve 3 minutes for rebuttal. Basically, we have 3 issues before this court on this particular appeal. The first issue that I'd like to discuss is an error of law that was created by the lower court in its ruling. The lower court had applied the incorrect burden of proof of preponderance of the evidence, and clearly it's been a long-standing case law in the state of Ohio that the correct burden of proof in an adverse possession or prescriptive easement type case is clear and convincing evidence. The second issue deals with whether or not the lower court failed to direct a verdict on behalf of Wakefield Run Homeowners Association because the appellee, Filip, in this case, failed to establish by clear and convincing evidence that his use was open, notorious, continuous, and adverse for a period of 21 years and to meet all elements. And then third, the other issue that we're going to look at is whether or not the lower court's finding is actually against the manifest weight of the evidence. In order to address the particular issues today, there's a few factual components of this case which are very important. The property in this case, which was owned by Jeff Filip, is at 24 West Boston Road in Hinckley Township. It was purchased by he and his wife and parents and deeded to them in 1985. It was titled to Jeff Filip, his wife, and both parents. In the year 2000, their loan was refinanced and that property was transferred from Mr. Phillip's parents' name into exclusively he and his then wife's name. And then in 2011, the Phillipses divorced and the property was then transferred to Mr. Phillips individually. The reason I point that out is apparently this property was owned by different people, and it's one of the component parts of adverse possession is that there were different owners of this property up until Mr. Filip acquired the property exclusively in 2011. He claims adverse possession of a portion of the property south of his property and south of the legal boundary line, which divides the property owned by the appellants in this case, the Wakefield Run Master Homeowners Association. At trial, this case went to bench trial on October 31st of 2013 and had 2 subsequent hearings post-trial to get or attempt to get an accurate legal description of what the court was trying to award to the appellant. May 26th, the lower court filed a supplemental final judgment entry granting the plaintiff's adverse possession of the area that was described in a legal description that was attached to the supplemental final judgment entry dated May 15, 2015. And I would like to point out to this court that that legal description was never put into evidence in this case, and we're somewhat unaware of how the court obtained a copy of that legal description. You'll note the legal description was dated May 15, of 2015. We did provide the court with a transcript of the last hearing before the court, which I believe was on May 23rd. And you'll note in that May 23rd hearing, there was never any submission of that legal description in the record. So as to the first issue, it's a pretty simple issue actually. A misapplication of the correct burden of proof is certainly an error as a matter of law. And it's pointed out at page 7 of the supplemental final judgment entry. The court found, quote, "The issue is whether Filip has proven by a preponderance of the evidence exclusive possession of the adverse parcel and open, notorious, continuous, and adverse use of the adverse parcel for a period of 21 years," end quote. I mean, clearly the wrong application of the burden of proof. To acquire a title by adverse possession, the party claiming title must show exclusive possession, open, notorious, continuous, and adverse use for a period of 21 years. And because a successful adverse possession action divests a legal title holder from his or her ownership, the doctrine is really disfavored. And that's continually pointed out in numerous cases, starting with the Ohio State Supreme Court case Grace versus Koch, 81 Ohio State 3rd, 577. Accordingly, the required elements are stringently applied, and each must be proved by that heightened burden of proof. By applying the wrong burden of proof, the court's conclusion is erroneous as a matter of law, and I believe this court recognized that judgment then may not stand in Copley Township Board of Trustees versus Lorenzetti, a 2001 case, 146, Ohio App.No. 450. With regards to that really concludes the issue number one, and to me it's a clear failure as a matter of law. As to issue number two, Mike Donaldson was the trial counsel on behalf of the Homeowners Association. He asked numerous, I believe at least 2 different times on the record, for a directed verdict regarding the burdens that had not been met by the plaintiffs in this case, or now the appellees. And he asked that a directed verdict be made in favor of the Wakefield Run Homeowners Association, and the court declined to do so. Now, the motion for directed verdict does present a question as a matter of law, and I believe that this court has the ability to conduct a de novo review of the entire record to make a determination as to whether or not the burden of proof was properly met by the appellee, Jeff Filip. I believe that standard of review is set forth in Bennett versus Administration of the Ohio Bureau of Workers' Comp, 134 Ohio State 3rd. And the elements that have to be met are more descriptively made in a case recognized by Grace called Roll versus Bacon. And you start to look at the evidence that's put on in the case as to whether or not it was an open and notorious use and it was not concealed. The court in Roll versus Bacon indicated that it is, quote, notorious, end quote, if its use is, quote, known to some who might reasonably be expected to communicate his or her knowledge to the owner, or so patent that the true owner of the property could not be deceived as to the property's use. In review of the record, there's a lot of facts here that I don't want to reiterate that in my time of oral argument, but in reviewing the record, most of the facts in this case do not indicate any particular use that was continuous for 21 years. In reviewing the record, we point out in our brief that there are times when Jeff Filip testified that he had a wood pile that may have been on a portion of the adverse parcel, but it was not for 21 years, and he readily admits there were times when that wood wasn't there. He indicates that his kids played soccer in this particular area, although he admitted that the soccer was not, the goals for the soccer were not really on the adverse parcel for the entire 21 years, and as a matter of fact indicated that the soccer nets and equipment had been purchased 10 or 15 years prior. Also, I believe there was a photograph that was introduced to evidence showing that the soccer nets had actually been dismantled and were actually up against the garage in the back, which was not part of the disputed area. The court continued in Roll then to look at continuous and exclusive as to that meaning, and said that all persons need to be excluded from entering, to be continuous and exclusive, all persons need not be excluded from entering upon and using the premises. However, neither the true owner nor third persons entering onto the land may claim a right to possession. And then lastly, which, there's actually 2 other elements. Adversity requires a showing of the objective intent to possess the property and treat it as her own, his or her own. What's interesting about the adversity is that definition is actually expounded upon in Grace versus Koch from what I believe is what the true review should entail, when the Vermont Supreme Court recognized in Grace at page 581 indicated that the burden is to establish adversity is, quote, the tenant must unfurl his flag on the land and keep it flying so that the owner may see, if he will, that an enemy has invaded his dominions and planted his standard of conquest. It really gives you an indication as to what the burden is here. And basically, an owner has to be put on such stringent proof that somebody is trying to take his land. You know, throwing a trampoline on the land and moving it around and all of the elements that are the court considered in making its finding really are all temporary and not permanent type uses of the land. There is a case, Stover versus Templeton, that does provide support for that argument, and that court said, we agree that by themselves incidental activities conducted merely to maintain the land, such as mowing, are generally not sufficient to establish adverse possession. Philip's general reflections of mowing grass then are insufficient, and it's well established that mowing the grass in neighbors is not enough to support an adverse claim. The Ohio Supreme Court in Grace expounded, saying that mowing grass, parking cars, recreational use and placement of firewood, oil drums, and a swing set on a strip of land presented an insufficient case to support adverse possession. And that's very similar to what the evidence was in this case. Periodic uses on an inconsistent basis, not continuous for 21 years. Philip even described the general activities of time in testimony with very little reference to any type of time, place, or continuous use. These generalities simply don't meet the stringent burden of proof requirements. And therefore, when Mr. Donaldson asked for a directed verdict on these particular issues, with this just being the only proof that was put forth, it's our belief that didn't meet the requirements, and the court should have directed the verdict on being in favor of Wakefield Run.
Let me quickly ask you a question. One of the things that I was concerned about or had a question about, there was evidence that a company called Kimball Hill put a drain on the parcel, and that Mr. Philip allegedly is the one who called and mentioned that to the Medina County engineer, I guess. Who paid Kimball Hill to install the catch basin?
That would be Wakefield Run. Yeah,
and was that a tax assessment that went on to their property taxes that they had to pay?
You know, I'm not sure how it was assessed to the homeowners, but yeah, it's an interesting fact that Mr. Philip, there was a drainage problem on where Kimball Hill had stored some topsoil on the adverse parcel or near the adverse parcel, which caused a draining problem. And it's interesting that if Mr. Philip believed that that adverse parcel was his and laid claim to it, he certainly didn't lay claim to the cost of fixing that problem. He called.
And counsel, you're in your 3-minute rebuttal.
Okay.
I just thought I'd bring it.
I'm sorry.
No, go ahead.
He called the Medina County engineer and had them then cite Wakefield Run and make them come and fix it. So it's interesting this claim.
So who made the arrangements to get it fixed?
Wakefield Run.
And that's in the record somewhere.
That is.
And that was in 2009.
That was in 2009, right. As a matter of fact, further into that record, in 2009, Mr. Philip made a comment within the record that the issue of the ownership of that property really didn't come about until that particular problem in 2009, which also indicates that he didn't really believe that he owned that property prior to that. I'll reserve the rest of my time for rebuttal. Thank you.
May it please the court, I am David Lenahan. I represent the appellee and the plaintiff in this matter, Jeffrey Philip. The appellant makes 3 arguments. Interestingly, the first argument where the court allegedly inadvertently used the wrong standard. It's clear that in the record the court referenced the wrong standard. However, at other points the court referenced the correct standard, particularly in ruling on the motion for a directed verdict. It referenced the clear and convincing standard throughout the trial. The clear and convincing standard was used in the closing briefs by both parties. The clear and convincing standard was used. The issue then becomes, in this unique case of adverse possession, what to do when the court referenced the incorrect standard. Do you remand it or do you fix it? I think the only time is that you can fix it is if there was in fact some prejudice to the appellant. And here there is a plethora of evidence. In fact, as the trial court indicated, there was no evidence to the contrary that in fact adverse possession had taken place.
So then you're basically asking this court to do a de novo review.
Yes.
And
Yeah.
say, and And not only just a de novo review, but basically put ourselves in the position of the trial court.
Yes, I think you can, because particularly the other assignments of error that the applicant is asking you to look at, this just bootstraps at St. Martin. He's asking you to take the de novo review on the other things, so you have to do it anyway.
But isn't there a difference between de novo review and putting yourself in the shoes of the trial court completely, in the respect that you're applying the correct burden of proof for the first time? It's never been applied before.
I think you're right. I think there is. But I think you end up with the same result. Because if you put yourself in that shoes as he's asking you to do, you'll see that there's just no evidence to the contrary, and all the evidence is there to support the adverse possession. The appellant wants to claim that you have to unfurl your flag, and the appellee didn't do that, but in fact he did, and the court recognized that he did. He planted a garden there. The garden had been there for 40 years, except for 2 times.
The problem I'm running into, though, is the 2009 French drain that was installed on there that wasn't paid for by Mr. Philip.
That's right. So what do you do when your neighbor puts a pile of dirt on their property that floods your property? You call the city and you call your neighbor and you say, fix it. You're flooding my property. And that's what happened here. The flood that occurred was because Kimball Hill, the excavator, the guy that was piling up dirt and shoved it to the back area behind the houses, started to flood the area behind Jeff Phillip's house that included the adverse parcel. And Jeff says, you're flooding my property, which actually included the adverse property. Kimball Hill and the homeowners just said, you know what, this ain't your property. We're flooding our own property. But they didn't. They conceded and agreed with Jeff Phillip that we're flooding your property.
Where's that written? Is that in the transcript somewhere that they conceded that they were flooding Mr. Phillip's?
Well, they did that by fixing it. By fixing it. When you call the city and say, my neighbor is flooding my property, tell them to stop and fix it, that's what they did. That's what Kimball Hill did. They fixed it. They stopped flooding the property, which included the adverse possession property.
Then it's my understanding from reading the briefs that there were 3 separate occasions where the Homeowners Association came out and surveyed the property.
No, there are 3 separate occasions where somebody in title chain surveyed the property as part of that, and never did anything further because it was the Sisters of Charity or some nunnery that was behind it that ended up selling the property to the association, or to Petros Homes, who then created the association, had various surveys or whatever done, and never one of them did they sit there and say, hey, we're going to now assert our rights and tell Jeff Phillip to get off that property. In fact, you know what they did? They built a fence on the other side of Jeff Phillip's property where they put the electric communications tower. And they actually moved the electric communications tower so it didn't even get within 20 feet of where Jeff had been mowing the grass, planting trees, planting vegetables in his garden. The kids were playing and doing everything else that a normal homeowner would do. Everything that a homeowner would do, Jeff was doing for years. And it got to the point where at the trial court, he was actually getting a little bit perturbed at how much evidence was being submitted to him that he took a break and said, is there a faster way that we could do this?
What would the Homeowners Association have to do, in your view, or in Mr. Phillips' view, to assert authority over that property?
Exactly what they did, or what they tried to do after the lawsuit was filed. They hired a company that brought out a bulldozer and bulldozed the property, and bulldozed the garden, and took all the stuff that was behind the property that was being stored there, and threw it back on Jeff Phillip's property. They finally did what they should have done after the lawsuit, and we had to get an injunction to stop them from taking any further action.
Was it green space as part of the Homeowners Association? Was it green space?
No. No, it was actually the front entrance. It's on like the main street. So there's a whole front entrance there as to where to the right of Jeff's house, which would be the westerly side. And then to the southerly side is what they call open space, back there behind some houses. Apparently at some point the city came out and looked at it and said, you know what, it ain't lining up right. I think your shed and your garage is on their property, which then started everything catapulting into asserting his rights to get the ownership, because Jeff had done it the same way the prior owner had done it for 30 years before that, and the neighbor and everyone else came out and testified to that effect. To claim that there wasn't adversity, that it wasn't continuous for 21 years, I think the court probably addressed that issue. You don't have to have 21 years of a garden. If you stop the garden for 1 year because you put in a septic tank, you're still using that property in that area to your own advantage, to the disadvantage of the property owner. For whatever reason, and it's plain, it was the way it was, and the prior owner used it that way, like the homeowner across the street testified, the property was just being used that way. It's a small piece of parcel that had continued to be used that way, contrary to the title owner, which was the Sisters of Charity and then Petros Homes and now the Homeowners Association that owns this land. I think at the end of the day, primarily because there was no evidence to rebut that the property wasn't used for a garden and wasn't used to bury dogs and wasn't used to do everything that a homeowner would do with their property. Planting trees, cutting down a tree fell down in a storm, he took care of that. The property owner didn't take care of that, or the title owner didn't take care of that, he had to take care of that. He did everything consistent with what a use would have, and these are one of those cases that you hear about in law school, you think you're never going to get because they're unique, and sure enough, 20 years in my practice, I got an adverse possession case, and I made sure that as we went through the trial that we proved it by clear and convincing evidence with so many pictures and so many people testifying, and they didn't have anything. The only thing that they had was, well, you know, you stopped the garden 1 year or a second year, or you take the trampoline down in the wintertime and you put it up in the summertime, but you do something else in the wintertime, and that the goalposts are not always permanently there, but other things were, and the use has been there, and even with all of the photographs at the trial that were introduced by the defendant, they all showed the mowing pattern. They all show the uses of that property consistent with the owner. I think as it relates to the Kimball Hills issue, which you seem to be struggling with.
Well, I guess my question is, when Kimball Hill dumped the dirt on the property, initially, why didn't he say something when they put the dirt on his property? Why didn't they call him and say, hey, get your dirt off my property?
I'm glad you asked that question, because I think that's demonstrating the misunderstanding that you're having. The dirt wasn't dumped on the property. The dirt was dumped next to the property. If you had homes and you had area behind the homes, that's where Kimball Hills was building up the dirt. That then ran downstream to where Jeff Phillips' house is. Kimball Hills didn't put dirt on the property.
So did the water flood not the part we're talking about, but Mr. Phillips' actual property as well?
Part of it, yes. Phillips' property and the adverse property to the south of it, because the dirt that was piled further to the south of that, in the green space or open space or whatever area that the homeowners association had. I don't want to say a quarter mile down the road, but several thousand feet behind it that caused all that water to come this way. So,
is there more construction going on back in there?
I think there was, and there still is. I don't think that was in the testimony. I'm thinking from my own knowledge of the area, because I live in Broadview Heights and I know the general area, and I think there were some homes that were still being built back in there, but I don't really know. But again, I think that question highlights that the area that flooded was caused because of some other area where the dirt was piled up. And really, if you think about it, this is a simple case of, as it relates to that issue, my property's getting flooded. It's getting flooded because of activities down there. You need to stop it and fix it. And apparently they felt that the easiest way to fix it is, instead of moving the dirt and grading everything properly, was to put a catch basin in and tie it back into the storm sewer system that was going throughout everywhere that it goes through. Clearly, if they would have put the pile of dirt onto the property, at best, all that would have done is it would have terminated the time period for the 21 years to be calculated. Because then at that point, Jeff Phillips could have said, wait a second, I've been using this property this way, you're now trying to use it a different way, do I have my 21 years or not? And at that point, I still think he had his 21 years, because I think we were at 27 years by the time we went to court. It was 85, 95, it was pretty high up there. So even if you add the time period on that, it wouldn't have benefited the homeowners if that's the time when they had finally asserted their rights to regain control of the property. And clearly, if that would have been the issue, we probably would have brought the prior owners in to substantiate the 40 years that this has actually been running the same way. We would respectfully ask the court to either affirm the decision because there was no prejudicial effect, And I didn't even touch on the other issues of the motion to dismiss or directed verdict. I think it's pretty fairly. And the manifest waste of the evidence is all there. The court got it right. We would ask the court to either affirm the decision because there was no prejudicial effect in this particular case, or remand it for the court to determine whether or not there was sufficient evidence to meet the clear and convincing standard that we'd all been arguing about from day one and even afterwards with the closing statements that were provided in writing to the court before he entered his decision, because this was a bench trial, not a jury trial. Thank you.
You have a little less than 2 minutes.
Quickly, the encroachments is kind of an interesting issue. In looking at the testimony that was presented by Wakefield Run, there were a number of times that people had visited that saw no visible encroachment to the property and no use by Mr. Phil. The record indicated that their testimony by Ms. Ververka had completed a boundary survey in 1999. She testified that she had walked the property and saw no visible encroachments and reviewed the file, and there were no visible encroachments. In surveying a property and parcel, this is something they absolutely are looking for. So she testified she saw nothing in 1999. Mr. Brennan testified that he also was the development director and walked the perimeter of the property in 2006 and saw no visible encroachments. And also Mr. Filip himself testified that he submitted a septic, or obtained a septic permit in 2004, submitted a drawing of his property which did not include the disputed property, and he also filed for a building permit in 2009 and submitted blueprint drawings that did not indicate that he owned the adverse parcel. So with that, we would ask that there was certainly evidence of no encroachments. We would ask that the lower court be reversed, that the second issue, that the court would determine de novo that the motion for directed verdict should have been granted and the plaintiff's case dismissed, and or in the alternative to reverse the lower court for applying the wrong burden of proof. Thank you very much.
Thank you. Thank you both for your presentation to the court. The court will take the matter under advisement, issue a written opinion that will be sent to both sides, as well as we'll release our opinion on our website.
Thank you.